There are two main things that your average patent attorney is going to be doing. One is going to be drafting patent applications. So patent attorneys will draft patent applications and file them at the United States Patent and Trademark Office. That is a large part of any patent attorney's docket at any given time. On the other side of that is going to be working applications through the patent examination process. They file the patent applications, and then there's a big examination process at the USPTO, and it's much like a negotiation. You file the application, it waits in line for 1 to 3 years, and then a patent examiner picks it up, does a prior art search to determine whether the invention as claimed is new and non-obvious compared to prior art, and you have to do this negotiation back and forth with the examiner, which can be multiple times. You receive an office action which has rejections, you have to draft claim amendments and maybe arguments, and then you have to file that with the USPTO, and then you get another office action. You may go back and forth. Sometimes it can be 6, 8 times. You may have to appeal things. So that process can be very involved. So those are the two main things that patent attorneys do. They draft the patent applications and they file them at the USPTO and then go through the examination process. And it really depends on the day, on the week, on the month. There are some days where all I'm doing is drafting patent applications, and that can be really, really time consuming. An average patent application is going to take, anywhere from maybe 20 to 40 hours, maybe more. The patent applications, a lot of people don't realize they are really dense and technical documents. So for instance, my technical background is in biochemistry, molecular biology. That was my undergrad, and I have a master's in electrical engineering. So I have to understand the technology as well, if not better than the folks that I'm representing. And so that's part of the technical writing is you have to describe these inventions in extreme detail. A lot of times you're going to have a lot of patent drawings, and you're going to have a lot of patent descriptions known as the specification. For instance, there are patent applications that I do, sometimes we'll get up to 100 pages. I mean, even on the short side, it's probably going to be 20, 30 pages. So these are pretty involved documents. So when it comes to the patent examination process, it's a lot of looking at prior art that's been cited against us in the office actions, doing an analysis to determine, hey, was the examiner right in characterizing the prior art compared to what we have claimed, and maybe drafting claim amendments to try to differentiate over the prior art that's cited. So there's a lot of really interesting analysis that goes into that. So I think that those two things, that's what most patent attorneys are going to be doing on a regular basis. And that may really shift. Like I said, there are times when all I'm doing is drafting patent applications, and that's my big focus. Whereas other times, all I'm doing is responding to office actions and maybe talking to the patent examiner on the phone, things like that. But it can be a little bit of everything. So there's no typical day. So most patent attorneys, that's what they're going to be focusing on. It's going to be drafting patent application in the examination process. But there are some other things that patent attorneys will do. Some patent attorneys have an extremely varied practice. They'll do business stuff, maybe they'll do copyrights, they'll do intellectual property, maybe trade secret stuff. They'll do litigation. But a lot of times patent attorneys will focus on just the drafting and filing patent applications and the examination process. But I know a lot of folks, they have a really varied docket where they're doing a lot of trademark work. And they would be sort of more broadly, intellectual property attorneys, where they, in addition to doing patents, they also do, trade secrets, copyrights, trademarks, and that's a big part of what they do. So, there's definitely no standard way that people practice, but I would say that, I don't know, maybe roughly, I'd say 80 to 90% of patent attorneys, they're going to be focusing on patent examination and drafting patent applications, because it's such a specialized thing. You have to have a technical background, like I said. You have to take a special bar, and you have to be an attorney. And so you might as well focus on, on the thing that you're really specialized in, which again is the, drafting patent application and the examination process. So one thing that people always ask is, well, you're a patent attorney, you necessarily do litigation. Some patent attorneys do litigation, but patent litigators, they actually tend to be very specialized in patent litigation. And so there are sometimes where I'll kind of do consulting on patent litigation, but really I don't lead the patent litigation. Litigation is so specialized compared to the patent examination and drafting process, and the way that you handle those things, it's a very full-time kind of thing. And so it's really hard to do both things at once. Patent litigators, surprisingly, they actually they aren't patent attorneys. That is, they haven't taken and passed the patent bar. And a lot of patent litigators don't necessarily even have a technical background like a patent attorney has to have to be eligible to even sit for a patent bar and to be able to represent clients before the United States Patent and Trademark Office. Patent litigators, they're more litigation focused. And if they need to get technical details, they'll rely on a technical expert, they'll rely on the inventors, and they'll rely on patent attorneys who do have a technical background and who have a background on what the patent examination process is like. So those tend to be very different practices. There was a time when I worked at another firm when I did a lot of patent litigation. It was difficult to balance both practices. I mean, there would be times where I was working, like, no joke, 90-hour weeks doing litigation. And so then my patent prosecution stuff would kind of get behind, and it wasn't wasn't really great. Also, I love patent prosecution because the people that I'm working with, it's engineers, it's scientists, it's entrepreneurs, it's people who are excited to work with me. Whereas litigation, you're working with opposing counsel, and people are upset. The clients, yeah, you're helping them out, but they're really worried about things, and they're really upset whether they're asserting a patent or whether they're defending against a patent lawsuit. It's really serious kind of stuff, and can be really heavy. And it's also really time consuming. So with patent, the patent prosecution practice, that's the drafting patent applications and working them through the examination process. A lot of times you have deadlines, you see them months out in advance. So it's a very chill kind of practice. I mean, I get to geek out on technology most of the day. In a lot of ways, I would say I'm kind of a glorified technical writer, which is great. I get to see all sorts of new, interesting technology. And that's why I love the practice of being a patent attorney. So what are some other things that patent attorneys do? So of course, we have to talk with new clients or existing clients in planning patent portfolios. And with that, what we're doing is we're planning patent protection for new inventions. And a lot of times timing is very important. You want to file as soon as possible because we live in a first to file system, which means that you only get priority as of the filing date of when a patent application is filed. But at the same time, it's better to wait until the inventions are as mature as possible before filing patent applications. So it's doing those analyses to determine, hey, when should we file patent applications? What sort of patent application should we file? Should we file a utility patent application? Should we file a design patent application? Should we file both? Should we file multiple patent applications? Because that's one thing that people don't realize is that a lot of times you have a single invention, but it can be covered by multiple patents. Even something relatively simple, I've filed 5, 10, 20 patents on relatively simple things. More complex things, there can be hundreds of patents on those things. And so sometimes you need to have patents on an overall system, maybe little small pieces of it. Maybe there are certain design elements that are really important that you want to focus on. Maybe there's software, and so you would patent the method of the software that things perform, methods of using something, methods of manufacturing. There's a lot of things that are potentially patentable. And as a patent attorney, we have to determine what should we go after in terms of protection. We have to prioritize these things. I mean, obviously, we could spend tons of time patenting everything, but especially for startups, we have to be really focused on things that have the best ROI, as in, you get the most return on your investment. So we go after, sometimes it's going to be the easiest things to protect, or it's going to be the things that are most valuable to the company, and obviously you want to protect the actual product that they have. So that's one of the great things about patent practice, is being able to do all this patent analysis, being able to dig into the inventions. That's a really fun part of what I do. So let's talk about some things that patent attorneys don't do a lot of, which may actually be surprising. One is patent and prior art searching. And a lot of people think it's a standard part of the patent process when drafting and filing a patent application to do a prior art search, because you want to know what's out there before spending all the money on a patent application. But surprisingly, and especially for the large companies, you never do patent or prior art searches. You absolutely never do them. It ends up being a huge waste of time. The only time that I typically recommend patent and prior art searches is for really small consumer products, which, where there may only be one small point of novelty, and it's a question of, hey, is it out there or is it not? One thing that people don't realize about patents is that they're more of a spectrum of protection. It's not just you have a patent or you don't. It's a question of, do you have a really broad patent that covers a lot of different variations, or do you have one that is so narrow and so specific that it would be easy to design around by making small, tiny changes to it? That's what patents are typically about for most inventions. It's a question of, are you going to be able to get a broad patent versus a narrow patent, instead of, are you going to be able to just get a patent? It's only on things that are really simple, where there's probably going to be one point of novelty. That's where you may want to do a prior art search. I've got some great videos about when you may want to do a prior art search, and another video about it's the top 10 reasons why you probably do not need a prior art search and why it's a waste of time. Another thing that we as patent attorneys typically don't do is infringement analyses. And that's another thing that people think is a standard part of the patent process. So they think that, hey, I have this product. Before I go out and I try to actually sell it, I want to make sure I'm not infringing on somebody else's patents. And by infringing, I mean, does the product, or does a process that you're performing with the product, or maybe manufacturing the product or related to the product, does that infringe on the claims of an issued and enforceable patent of somebody else? And people will think, hey, I want to be a good citizen of the business community. I don't want to intentionally infringe on other people's patents. That wouldn't be a good idea. I don't want to get sued for patent infringement, or be, have cease and desist letters thrown at me. That's not fun. I don't want to be shut down as a business. But the surprising thing is, it's actually extremely difficult to do an analysis like that. It's really expensive, and a lot of times people want to do this analysis at an early stage of a company when they just have sort of a kernel of an idea. They don't really know exactly what they're going to be doing. And when it comes to patent infringement, the devil is in the details. It's all about this very specific things you're doing or not doing that make all the difference when it comes to infringement or non-infringement of somebody else's patent. And so, that's why it's kind of cart before the horse. Is, in the early stages, well, you don't really usually have enough information about what the product is actually going to be in order to be able to do a good infringement analysis. And so a lot of times it's only after you've done all the work and you have the product, that's when you may be able to do an infringement analysis. But even then, it doesn't make a lot of sense. You've already invested all this money, and just because you may infringe a patent of somebody else doesn't mean it's ever going to be enforced against you. So that surprisingly is something that we very, very rarely do. We don't do patent and prior art searches. We don't do infringement analysis very, very much. A lot of times, it just makes sense to file the patent application. So there's two ways to start the patent process. There's a provisional patent application and a non-provisional patent application, and that's part of the analysis of clients' products, is determining, hey, how do we start the patent process? Do we start with a provisional or do we start with a non-provisional? For startups and for smaller companies, we typically start with provisional patent application. The reason is it gives a lot more flexibility. And maybe let me step back a minute and kind of talk about the two ways you start the patent process. So one is with a non-provisional patent application, and that's the one where you file it and it waits in line at the USPTO before it's examined. Typically that's 1 to 3 years. And then there's the examination process, and we kind of talked about that. That's one of the big pieces of what we do. So the non-provisional waits in line, it's examined, you have this examination process, which is like a negotiation, and hopefully the examiner agrees that the claims you have are new and non-obvious compared to prior art, and then allows the case, and then you pay an issue fee, and then it issues as a patent. So that's starting with the non-provisional. The other way, and again, like I said, this is why I almost always recommend for startups, is filing what's called a provisional patent application. So provisional patent applications, they are just placeholders. They only last for 1 year, and they are not examined. They just sit there. You file them. What you do is you file the provisional patent application. It lasts for 1 year. Then you have to file the non-provisional patent application, and it claims priority back to the provisional. So provisionals are beneficial in many ways when it comes to startups. One is it's a lot more cost effective. Startups need to focus their money on things like R&D, on marketing, spending money finding investors, doing market testing, things like that. So they should keep their IP costs at a minimum. it's really important to keep costs as low as possible. And provisional patent applications, yeah, they can be really expensive, and they can be, of a quality that is exactly the same as a non-provisional. They're really formal, having all the formalities of a non-provisional. But a lot of times it makes more sense to just do a really quick and dirty provisional application, one that is drafted by the inventors, and then have a patent attorney scrub that and file it as a provisional patent application, just so that they can start making public disclosures, public use of their offers for sale, and approaching investors. Provisional applications are great for that. Also, it provides a lot of flexibility because, anyone who has worked in startups knows, hey, what you do at one time, there's R&D, and you get it in the hands of consumers, or you do focus groups, and you realize, oh my gosh, this product isn't great. We need to refine it more, or a lot of times these folks will totally pivot and do something that is totally different. So that's why a provisional is good as well. It allows you to add things either at the non-provisional stage, or sometimes what we'll do is we'll file a provisional and then we'll file another provisional and then file the non-provisional at the 1 year anniversary from the first one, and claim priority to both of those and be able to add information at all the different stages. It provides a lot of different, a lot of flexibility for folks. So that's another great part of my job, is doing this customized, bespoke analysis of my clients' inventions. I love doing that. So that's kind of, one of the main things that us patent attorneys do. So hope you enjoyed the video. Thanks for watching. I'd love to hear your questions down in the comments. I'd love to know what you thought about the video. Is there something that I left out? Do you have any additional questions? What other things would you like to know about what patent attorneys do or what patent attorneys don't do? Would you like to see more videos about patent careers, things like that? Would that be useful to you? Let me know down in the comments. So again, thanks for watching. If you're looking for more information about startups and about patents, be sure to subscribe and hit that little bell icon so that you get notifications when new videos come out. So we will see you again in the next video. Thanks.